The Rehabilitation Act of 1973 prohibits any discrimination based upon physical and/or mental disabilities. This act is a civil right extended to people with disabilities through Section 504. It was introduced in the 93rd Congress on May 23, 1973 by Senator John Bradmus of the 3rd District of Indiana and was enacted September 26, 1973, signed by President Richard Nixon. The act in part says no otherwise qualified individual with a disability in the U.S. shall solely by reason of her or his disability be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance. The Rehabilitation Act of 1973, while encompassing all people with disabilities from discrimination, Section 504 of the same act focuses mainly on protecting people with disabilities in programs that are federally funded, such as elementary schools, high schools, universities, and federal-funded training programs. Section 504 provides the Client Assistance Demonstration Project and provides people with information for all the benefits accessible within the Rehabilitation Act. Let's go back in time to the earlier 1880s. For people with disabilities, it is a much different time. There were very little laws protecting the disabled. In fact, quite the opposite was happening. In Chicago, 1881, an article was published in the Chicago Tribune stating that Alderman Peavy prepared a new ordinance. The ordinance was to abolish all street obstruction. The ordinance that Mr. Peavy brought before the council made it sound more innocent regarding the ugliness meant for street rubbish such as construction debris. Unfortunately, the ugliness turned out to be human beings. The ordinance that Mr. Peavy issued passed and Chicago ratified the American Ugly Law, which states, any person who is diseased, maimed, mutilated, or in any way deformed so as to be an unsightly or disgusting object or an improper person to be allowed in or on the streets, highways, thoroughfares, or public places in this city shall not therein or thereon expose himself to public view under the penalty of a fine of $1, about $20 today, for each offense. Chicago City Code 1881. Let us roll forward in time to the early 1970s. We find that children with disabilities are not protected from discrimination from peers, teachers, and administration. Many students are being suspended or even expelled on a regular basis because of behaviors due to their disability. Many are let out unto their own devices or placed into state institutions. Individuals with Disabilities Education Act was established for this very reason, to safeguard students from being removed without their parent or guardian's permission. The student also has the right for free and appropriate public education, FAPE, as well as environment that is the least restrictive possible, LRE. The schools have the right to discipline the student with disabilities appropriately. In fact, by not addressing the behavior, some say the student is being neglected and not receiving appropriate education. Today's education environment is much more conducive for students with disabilities. The resources available is paramount. A parent of a disabled child can peruse the internet and will be informed of the plethora of resources they can partake in. The future is bright for those who have disabilities. Schools and federally funded institutions are becoming more aware of the need of students with disabilities. Access to resources have never been easier to find, and the ability for schools to grant resources and counsel parents is growing much faster than ever before.